over there, staff conference, someone who always offers tremendous insights at the interaction between law and statistics and probability. Paul Roberts.
Thanks very much, Norman. Thank you to all the organisers for bringing us all here today. Thank you in particular for inviting me to speak. Yeah. So, I love France's talk. That was excellent. Thank you. I think two things to mention about that as a way of setting up what I'm going to say as well. So I think Franz in particular was talking about how you engage with naturalistic human reasoning, given that, as we all know, people are not, quotes unquote, natural Bayesians. So you have to find a way to engage with their naturalistic reasoning processes in order to make sense of these approaches for ordinary people, mere mortals, non-Bayesians. But there's another level of engagement as well that's going on there. And notice again that what Franz was talking about is very much aligned to Dutch criminal adjudication. And in particular, the fact that in the Netherlands, fact-finding in adjudication is a professional activity. It's done by judges. You also talked about it being addressed to prosecutors, Franz, but of course in the Netherlands, prosecutors are also judges, right? They're part of the magistracy. So these are really different things. And it raises again this point about being careful about these comparative borrowings and so forth. And I want to bring out some of that as I proceed. Today, this is not a counsel of despair for us in England and Wales. On the contrary, it's an encouragement to look for other productive ways of engaging with criminal proceedings in general, not just trials by any means, but the criminal process in its entirety. So, for example, the kind of things that Franz was talking about might well be effectively addressed to police officers and detectives at the investigative stage, even if this approach would not be appropriate in England and Wales at the trial stage for judges. So just one example, picking up on that very good presentation there, which kind of illustrates in a concrete way what I want to talk about, because I hope you'll see that I'm not off topic and that I am addressing the question that our organisers asked us to address. But I'm doing it, if you like, at a meta level. I'm not talking about the substantive issues. I'm talking at the meta level, or if you have to give it a methodological level. In other words, how we go about thinking about those kinds of questions. Okay? Now, when I first started worrying at these issues 25 years ago, became very quickly apparent that one big problem in England and Wales was that lawyers just didn't talk to experts. They literally just didn't talk to them. Often, the first time that the barrister encountered the expert was in their examination in chief in court. There was not nearly enough talk. So-called conferences with experts might actually be a snatched 5 minutes in the corridors of the courtroom, where the conversation goes something along the lines of, I've got your report, boffin, are you saying this? Yes, fine, off we go into court. Right? So a problem was...
No, not my experience at all.
Can I be absolutely clear about this, that I am talking about criminal adjudication? And nothing I say is to be extrapolated to civil litigation at all. This is a really, really important point. The doctrinal law, let alone the practice of criminal adjudication in England and Wales, is nothing like the civil law. What I'm talking about, unless the context requires otherwise, is criminal adjudication in England and Wales. But thanks, Jane, it's a good qualification. Make that clear. So at the time, I wrote a paper and gave several presentations called Can We Talk? Can lawyers and scientists talk to one another? Since that time, it's fair to say there's been a lot more talk. Not least of all, fantastic occasions like this one where diverse groups come together and share knowledge and experience and perspectives and so forth. So there is more talk, but it seems to me, as you can tell from my gently provocative title, that talk is not enough. Because talk might be at, or over, or even to. And talking over, or at, or even to is not good enough. Because what we need is talking with. In other words, we need proper conversation and not just talk, not just more talk. And so, what I want to, my main message today is about how we move from lots of talking to genuine conversation where we really start to understand one another and move forward. Final prefatory remark, that's kind of two-track. When I say can we talk, I do mean scholars, people like me who live in the university and never left, but also practitioners too. I'm interested in the complex ways in which those scholarly and research discourses interact with practitioner discourses as well. So it's the whole caboodle. So if I can distill into 3 words what I think I've learned over 25 years worrying at these topics, is that the 3 eternal threads of these things: communication, complexity, and interdisciplinarity. I hope you'll already see that much of what we've been talking about for the last 2 days fits under these headings, and it, if one sees this as some kind of hypothesis, my own experience is that it's continually confirmed. It may be confirmation bias, I don't know, but communication, complexity, and interdisciplinarity is what we're all about. And I want to say a little bit in my diminishing time about all 3, but mainly about 1 and 3, less about 2. So, just one little reminder here that, and the lawyers will all understand this very, very well, and many non-lawyers too, these are not just intellectual problems for us. Criminal justice is the sigh of broken bodies and ruined lives, not to be too dramatic about it. Criminal justice, nobody wants to be there. Complainant doesn't want to be there, the defendant certainly doesn't want to be there, most of the witnesses don't want to be there. On a bad day, not even the lawyers, really, I think. Miscarriages of justice, in a phrase, is what happens in my world when people make mistakes, and this is serious stuff. Now, the thought that miscommunication, communication failure to understand one another is the cause of miscarriages of justice is not a new thought. Notice the date, 1991. Just this is the British section of the International Commission of Jurists did a report on causes of miscarriage of justice. I can read from the quote: communication failure is a big part of what goes wrong. So some of you have seen this before. This is my trademark slide. In a nutshell, the problem of communication failure by that great American philosopher, the cartoonist Gary Larson. So on the right-hand side, you have the dogs version. What we say to dogs: okay, Ginger, I've had it, you stay out of the garbage. Understand, Ginger, stay out of the garbage. Or else, what Ginger hears, blah, 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 Ginger, blah, blah, blah. And then, of course, for cat lovers, you'll recognise this. The cat version is what we say to the cat, what Fluffy hears, nothing. Now, the main lesson of this slide, for me, and I want to share it with you if you don't already know the lesson that I heard me say before, is that when you show this to scientists, they assume they're the pet owner. But when you show it to lawyers, they think they're the pet owner. Now that starts to become quite interesting, right? Because I've already heard over the last 2 days phrases like scientific illiteracy and so on, and I'm good with that. There is a lot of it about. But for every frustrated forensic scientist, I can show you a practicing lawyer who will tell me that you can't get a straight answer out of the boffin, and the boffin can't understand the difference between direct testimony and evidence and hearsay, and they don't seem to appreciate that extraneous bad character evidence is inadmissible, and, you know, God save us from the boffins. So, like France, I'm not in the blame game. If we wanted to spread blame around, there's plenty to go right around, and there are no innocents in this story. But I'm not interested in that anyway. I'm interested not in blame, but in diagnosis. Because if you don't diagnose what the problem is properly, your prescriptions, your solutions, they ain't going to work. Particularly in an environment that is as fundamentally complex as criminal adjudication. We've heard many references to complexity over the last 2 days, and trust me, it applies in spades to criminal adjudication. Problem is mutual incomprehension and misunderstanding. Lawyers have their version of this, scientists have their version, and of course, nobody can do the math. Just give you a moment to have a look at that and see if you recognise yourself in any of these images. What causes a miscarriage of justice? A hell of a lot of different things. So this is a complex topic. But certainly, an important part of this is that the evidence was misunderstood, and that's of course where these issues around probabilistic methods and how you communicate DNA, and so much of what we heard about in the last 2 days, that's that part of what goes wrong in miscarriages. I've written a paper on this, by the way, which was published as part of the Royal Society's collection on new paradigms that came out in their journal last year. This is only a précis of that presentation. I actually come up with 20 causes of miscarriage of justice. I wasn't even really trying very hard. That was just a summary. There's a lot going on. Misunderstanding and miscommunication is part of the picture. Now, in the context of this presentation, the case that's always comes up in England and Wales is, as you know, many of you know, the Sally Clark case. It is, by any analysis, a tragedy, however you look at it. It led the president of the Royal Statistical Society to write to the Lord Chancellor, and by the way, that's in the days when we had a Lord Chancellor who was actually a lawyer and knew about the rule of law, but those days are gone, to raise an issue about the use of statistical information in the Sally Clark case. Many of you know the story. I've edited the letter, but it more or less concludes by saying the Society urges you, the Lord Chancellor, to take steps to ensure that statistical evidence is presented only by appropriately qualified statistical experts, as would be the case for any other form of expert evidence. It's a nice sentiment, but that's going to happen just about between when pigs fly and hell freezes over. Because the reality is, as I've already mentioned in interventions, that most statistical information is given by non-statisticians in criminal adjudication. There's no way that is going to change, practically speaking. That means, of course, that those experts need to understand the stats, as does everybody else. So, this is one of our organisers' descriptions of the case. It's a lovely narrative. Up stepped the witness, Roy Meadow, paediatrician, not statistician, gives the number, does the math error number 1. Coming down, the jury were left to choose between one chance in 73 million, that's the key probability or statistic, I think it's a probability, that it happened by chance, and otherwise she killed them. How could they hesitate? Thanks to 1 in 73 million, Sally Clark had suddenly become the most hated citizen of Great Britain, apparently. So that's how, on this account, the miscarriage of justice came about, and it was the math what done it. Now, if you actually look at the case and read what happened, it's so much more complicated and complex than that, and it's not even clear that Meadows' mistake in the witness box had any bearing on the outcome of the trial at all. So it's just one example of how, you know, somebody, as it were, from the outside can come along, and I don't know if they read the case, but I presume they read the case reports, the appellate judgments, and look at what was said in the papers, and really get completely the wrong end of the stick. Now, if you're a lawyer, you know, if you're a lawyer and if you take taxes, and I'm both those things, then you will become very used to members of the general public having lots of opinions about criminal adjudication on the basis of not very much information. So, you know, there is an issue there about complexity and about communicating what's going on. This is my one slide about complexity is this. We're dealing with multidisciplinary fields. So, just as Fran said, don't shoot the messenger as far as Bayes is concerned, reality is complex. I'm making a similar point here about the need for interdisciplinarity, not because some little philosopher thinks that's what we need, but because reality is like that. And you've heard that from working forensic scientists over the last couple of days, that they need a range of specialisms. On the law side, you know, and non-lawyers talk about the law as though it was a thing, you know, the law. I don't even know how to respond to that as a law professor, because there are so many different dimensions to this. I've already mentioned in response to Jane's helpful intervention that criminal justice in England and Wales is completely different to civil adjudication. When we think about law, these are just some of the main dimensions that we need to have in mind, and I've made some of these points in intervention, so I won't milk this too much now. But one important tension is the difference between law, by which I mean positive law, the law of a particular jurisdiction, and broader notions of justice. And what, you know, how those two ideas play out together. If we think about justice as a sort of philosophical problem, then yes, epistemology, the epistemic factors, are part of that mix. But from my understanding, they're actually subsidiary, and this is something that Christian was getting to in one of his earlier interventions. Essentially, criminal justice is fundamentally deontological. It's about normative values, and the epistemological problems are plugged into that afterwards. Statistics and statisticians can help us a great deal with that part of adjudication, which is epistemological. But as I mentioned previously, I don't think they've got much to say, other than as an informed citizen, that's fine, about the deontological aspects. In other words, the answer to the question, what is justice? When we talk about law, there's a great complexity there as well, because legal scholars and legal law students are familiar with the distinction between the idea of the law in the books and the law in action. And the law in action may or may not fit with the law in the books. Sometimes the law in action subverts law in the books. Often it adapts it or changes it in various kinds of ways. So when people who have experience of actual adjudication talk about the law as it's practiced in a particular court, and that's of course their experience, and it's valid and true at that level, what I want to ask as a law professor is, was that behaviour of those people actually lawful? Because it turns out, you know, that a lot of what lawyers do is either not clearly legally regulated in some kind of like an area of debate in terms of the legality of it, or sometimes, frankly, lawyers don't follow the law. You know, so I often get, I get these stories about, oh, this happened to me in Crown Court so-and-so, and I say, well, I'm sorry to hear that and that you had a bad experience, but you know, stuff goes on in Crown Court. I really can't tell you much about that. What I can tell you is what should have happened. And I get that from reading the reports of appellate cases that create precedents. And Bernard Robertson's already mentioned that as law professors, we spend most of our time actually just reading what the Court of Appeal says, and we don't really know very much about what happens at the trial level, as a matter of fact. Now, procedural tradition, I've mentioned this already, and I've milked that. I just want to say about this as well. One of the big themes in comparative criminal procedure nowadays is, some people call it globalisation. I prefer to use the term cosmopolitanism. I've got an account for that, which I can't give now. But in any event, what this represents is, in our modern time, law as traveller, law as cosmopolites, a citizen of the world. Law moves about, it changes, and different legal systems influence one another. Particularly in the European context, and while we contemplate the meaning of Brexit means Brexit, let me just emphasise to you that when I say European in this context, I'm talking about the Council of Europe. Council of Europe system, where it's the Strasbourg European Court of Human Rights, that is the relevant institution, and it's the European Convention on Human Rights. This has got nothing to do with the EU. If I had more time, I would test you on your knowledge of the difference between the EU and the Council of Europe. I'm not going to do that, but trust me, whenever I test people, the results are not brilliant. They're probably not any better than what you find when you test people's understanding of Bayesian reasoning, quite frankly. So let's be clear, whatever happens with Brexit, we're still going to be in the Council of Europe, and the Council of Europe requires that all 47 states parties in the Council of Europe adhere to minimum standards of fair trial, and that's one of the main agents within that larger European theatre of cosmopolitanism. There's a convergence in criminal procedure, and we're all becoming more and more similar. So this is even more complexity, in other words. Now, as time moves on, let me get to a more positive dimension of what I want to talk about. Last piece of diagnosis. Interdisciplinarity is hard. Interdisciplinarity is hard because it's not just about learning a new language or new terminology or new ways of thinking even, or new tools and technologies. It's about complete worldviews. It's about what you think is the issue or is the problem. And one way of encapsulating this was Wittgenstein famously said that if a lion could speak, we couldn't understand him. And the point of that aphorism is that in order to understand the lion's words, we need to understand what it was like to be a lion, to see things from the lion's perspective, to have the value system of a lion. And interdisciplinarity poses that problem of moving between different Weltanschauung, worldviews. And that's not easy. It's a two-way street, but to go right back to Alan Jameson's point, if we're talking about forensic science, you are in my house now. I'm not trying to tell you how to be a statistician, but if you want to engage with criminal adjudication, then in a sense, it is our pitch, our rules, our ball. We're more than happy to have you play for us if you're a good player and you can help. And this has been English law's position on this since, in recorded cases, the 16th century. There are precedents going back in the common law for 400 or 500 years saying, we love experts, help us. But it has to be help on our terms, and specifically in terms that cohere with prevailing understandings of criminal justice, the deontological basis of that. So I came up with 9 rules. I need to go quickly here because I'm running out of time. I'm trying to be positive about rules for conversation here. And genuine mutual understanding and not misunderstanding. Nothing is self-evident. Define key concepts. Now, you can't spend all your life defining key concepts. You would become a very boring person if every presentation you gave a lot of definitions before you got going. It can't be done like that. It's a little bit like the one about the Oxford English Dictionary being strong on definition but short on plot. So, what I'm saying by define key concepts is A, make sure you know what you mean when you use a particular concept. Second, make sure that the person you're addressing shares the same meaning of that concept as you do, and then you can proceed profitably. Otherwise, you will fall prey to what the legal philosopher Ronald Dworkin called the semantic sting fallacy. The semantic sting fallacy is when we have an argument about whether the banks are collapsing, and after 2 days of arguing, or in the case of forensic science 100 years, it emerges that when I said the banks were collapsing, I wasn't referring to the credit crunch, I was referring to the loss of river habitat for beavers and otters. Right? That's not a dispute. That's just a big mistake the whole way through. And too often, discussions in this field fall prey to that semantic sting. 3, appeals to logic rarely win arguments in this context. Bayesians are very fond of saying, but it's logic, and it is. But 9 times out of 10, the issue is not logical or not logic, it's salience. Can that logic help us? It's a bit like saying 2 + 2 = 4 is logical. Yes, it is, but that's not helping me adjudicate this criminal case. 9 times out of 10, it's not a matter of logic. 4, in normative enterprises, of which criminal adjudication is absolutely one, ethics or political morality, I didn't mean professional ethics, by the way, I meant the subject of practical ethics, always trumps science. Science is just instrumental. It can tell you how to do stuff. It can't tell you whether you should do it. Science can tell you how to build the atomic bomb. It can't tell you whether and whom to drop it on, right? I mean, we all understand this. So this is how criminal justice works as well. Science, including Bayesian tools, might help us get to the truth. It can't tell us how we should value the truth relative to other values. And we do have other values. In a criminal adjudication, we think it's important not just that we find truth, but we do it in a particular way. Sometimes it's more important that the right person decides than that the truth is found. Now, you think about these things. These are just general truths in philosophy. 5, useful one. If something looks stupid when you first look at it, look again, because you probably haven't understood it. Even if the rationales that are given for it don't hold water, there's probably something else going on. The history of the law, it's a slight misquote, has been not logic but experience. You know, the law has been developing in this way over a long, long period of time, and some of that experience is not stupid, even if it might look like it at first glance. So I'd urge you to look again. I was going to give lots more examples here about Spot the Transposed Conditional is one of my favourite party games, and I don't go to many parties, actually, funnily enough. So I wanted to talk about Mr. T, but I can't do any more on that. What do you know about criminal justice, and who have you got it from? Practicing lawyers, for example, are often not good authorities on what the criminal law is. They're good authorities on what they get away with in their court. They're not necessarily good authorities on what the law is. Meaningful interdisciplinary communication takes a lot of time and effort. So we must, have these events over and over again. And I've seen many of you before. I've met new friends here. It's all good. We keep doing that. We keep telling people. It's a battle that is not, won conclusively on a particular day. It's an ongoing struggle. And remember what Lonica said as well yesterday about the fact that a lot of the people we really need to talk to don't even think there is any kind of problem. They're not even motivated to worry about these things if you're talking about judges and lawyers. So one thing I really need to emphasize in everything that I'm saying is whenever you have these kind of discussions, the people in the room are not the people I'm worried about. If you're here, you care. And if you're here, you're worried about interdisciplinarity. And good, let's learn from one another. What we need to then worry about is helping all those other people out there get these points, the people that are doing the job and teaching others to do it. 2 more minutes, if I may. Read widely, right across the library. There is a big problem with, we know this, it's part of the modern condition. Knowledge becomes fragmented. There's some kind of statistic that half the information ever created by human beings was created in the last 10 years, or whatever it is. We've got information explosion. How do you deal with it? We've got disciplines becoming more and more siloed. And a problem with that is that the same debates sometimes go round and round and round. There is a very good set of articles and literature going back to the early 1970s in US law reviews about Bayes. Have you read it? Rick Lempert, I'm slightly embarrassing him, wrote in 1977, Michigan Law Review, one of the best things you'll ever read on Bayes and the law. Modelling Relevance, a fantastic article. All my students know that article. It was written in 1977, so just occasionally, rather than write that article again, spend the time reading Rick's version of it, and that'll be a good way to move forward. Finally, just to really underline that when I say our rules, our pitch, our ball, I'm not saying don't play, we don't want to play with you. I'm absolutely not saying that. We want everybody involved because I've already said it has to be an interdisciplinary endeavour. It has to be that. Take heart. Don't give up. Many of us have been doing this thing a long time. Keep going. Try again. Mere talk is better than no talk. But proper conversation would be even better. So that's really what I want to finish, and I'll just leave you with on materials, because I see I'm following Bernard's lead here of self-promotion, and most of you, I hope you are aware of this sequence of reports that Colin and Roberto and Sue and I did for and Graham Jackson for the RSS. They are free to download. I emphasise that the kind of theory I'm interested in is the theory with a real practical buy. I'm in this not for theorising's sake. I am a theorist, hands up, I'm a theorist. But I'm interested in theory for its practical output. It goes right back to the original purpose of philosophy, which was to solve practical problems and figure out how shall we live. That was the Socratic question. So this is all free to download. We hoped, Colin and I and others, we hoped that this would be kind of a practical tool that people would use. I guess we thought we'd try and provide some kind of definitive statement, but of course it's never definitive. And one of the reasons I want you to read this stuff is so you can tell us what we've got wrong. Because we learn by that iterative process. Is this the last word on it? You must be joking. It's, if anything, it's the start of the conversation. But trust me, Colin will back me up on this, producing these 4 reports was not easy. Right, Colin? It took a long time for a statistician, an academic lawyer and a forensic scientist to agree the wording of every line, of every sentence. Colin now introduces me, he did this week, as this is Paul Roberts, I sometimes have to correct his transposition of the conditional. Now, this is perfectly true. However, thanks to Colin dinning it into me over 5 or 6 years every time I got it wrong, I think I'm right in saying I do it far less than I used to, so there can be progress. Colin didn't realise that this would be a job for life, which it is. It re-emphasises the point of the need to keep telling these messages, good messages, and, to keep talking. Let's have a good conversation. So I'll stop there. Thanks very much.
This was a great talk, and everything you said was right, but some of the things you said are contradictory, it seems to me. And one of the things you said is it's hard to get people to care. And the other is you have to respect the complexity of the situation, but sometimes in order to get people to care, you have to simplify. And actually, I myself, I'm not a forensic scientist, but my interest is really communicating more with the general public, even more, talk about lawyers and judges, even wider. Young people, those are the future. And you have to simplify, and you have to cheat a little bit to do that properly. So complicated game.
I don't think it's contradictory. I think that's another version of Franz's "the world is a complex place." So just one definitional point. I meant to say this. My understanding of forensic science encompasses reasoning tools for inference. So when I say forensic science, I don't mean it in the idiomatic way in which people generally use forensic science. I've got a whole paper to explain why so I absolutely include within. So when people say I'm not a forensic, you are in my terms, because we're in that game, right? Now, so when you broaden it out to the public understanding of science, right, as an enterprise, obviously there are trade-offs to be made, and I do take the point. Lawyers simplify for a rhetorical effect the whole time. I think that what I would say about that is we all need to get more savvy about understanding when people are being reductive on purpose for an objective. In other words, to read each other's work in a more sympathetic fashion, rather than, my example of the spot the transverse condition is, the point of that is, if you get into your head that people are doing this all over the place, you go around looking for it, and then that becomes the only thing you've got to say. Transpose the conditional. Now, when people do this with regard to legal judgments, it's mostly not having a bearing on the judgment. Now, am I saying it doesn't matter if lawyers and judges get it wrong? It does matter. Of course, it would be better in an ideal world if they didn't make silly mistakes. But for me, as a lawyer and somebody who's interested in the quality of justice that's dispensed, I'm more concerned with the overall justice of the proceedings, rather than whether the judge or the lawyer's made a slip of the tongue at one particular point.
But it's not always clear it had a bearing. Like the Sally Clark statistic, many people said, "Oh, but that didn't have a bearing." But then you go to the Lucia de Bell case, and there was another statistic similar there. Oh, but that one didn't have a bearing, and but they did.
So we can say in one way in which it certainly did not have a bearing, and that is that it was not the basis for quashing the conviction. Because at law, the basis for quashing the conviction was the failure to disclose the pathological
Of
evidence.
course.
So in what it... No, quite. But
Oh no, the judge said in the second court of appeal that would have been enough in itself.
They said it might have been.
Without.
I'm going to need to. I did promise Julia the last question. That was going to have to take.
Very nice talk. Just a comment on your fourth rule of prescription. Can you show again the number 4, where you had about moral and momentum? Yes.
I have to go through Mr. T's first, that's it. We've got Barry George and Mr.
Yes.
T. There's number 4.
About ethical, political, moral, always trumps science. The problem here, I already want to comment on something like that. Here there is a mixture, because it's not just morality, judgment over logic and probability. There are different issues which are combined, which is logic, probability, decision making, game theory. Where the judge judges, it takes all this in account. For example, he has to prevent other crimes. And then it's also important. He's not sure, but he's sure that if he convicts somebody will not do a similar crime. I think for me it's very important to clarify the different contribution and say, this is the contribution of logic and probability, this is the contribution of decision, I do this because of that, and so on.
You know, it's even more, I agree with that, and it's even more complicated, because I'm using science here in the Anglophone sense, but most Romance languages don't use science like that. So in German, one can talk of the Rechtswissenschaft, which is legal science. Now, the phrase legal science in English just doesn't, people go, what? Law's not science? It is in Germany. And, you know, when my friends from continental Europe greet me at congresses, they say, fellow criminal scientist. I mean, so language, there's always language stuff, you know? Yeah, absolutely.
Thank you very much.